These are the plaintiffs, Neil and Avril Haberman. Neil says he and the defendant agreed he would buy their limo business and gave him a deposit, and they had a closing date scheduled. At the last minute, the unscrupulous defendant backed out of the deal and now refuses to return their deposit. This is outrageous behavior. The judge needs to set this guy straight, and they're here suing him for the $1,000 they are most certainly owed. This is the defendant, Scott Wilkins. He says the plaintiffs missed the first closing date because they couldn't come up with the required $50,000 payment. He was a nice guy, so he made a new closing date. And again, the plaintiffs reneged because they couldn't raise the money. Well, he's sorry, but they had two closing dates. The plaintiffs failed to close, and he gets to keep their $1,000. He's accused of standing his ground. The defendant has filed a countersuit for $2,500 for wasted time.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiffs say the defendant agreed to sell his limo business, but at the last minute he backed out and wouldn't return their deposit. The defendant says the plaintiffs botched the deal so tough. It's the case of limo madness.
Thank you, Douglas. Okay, Mr. Haberman, you
Yes,
were in the two of you, I guess, were in looking to expand your business. What is your business?
We have a car service in the Sarasota area of Florida.
Okay, and you also have a car service,
Yes.
and you're looking to get rid of it.
Sell, yes.
How long have you been involved in that?
18 years.
Okay, and this is your wife, and who is this?
My daughter.
Okay, good, because you never know. All right, are you in the business as well?
Yes.
Okay, so how do you find him and his, did he advertise it?
We had a mutual associate.
All right, so that person, that mutual associate puts you two together,
Yes.
and you two talk. And the first plan is what? Is it actually in writing, the first plan?
We have a letter of intent that we both signed
Okay,
on.
and the idea was, how was the purchase going to be made in that first attempt?
It was supposed to be, I gave him a $1,000 down payment,
Okay?
okay? Then I gave him an additional $9,000 down payment
Is that still in the before the first closing date?
after the first closing
Yeah.
date.
So how was the first closing date supposed to go down? You're supposed to get your own financing?
Right.
He's not taking any paper back or anything. He's not loaning you money to buy it and then taking payments
No.
from you later. All right. So the first closing passes
Right.
and you can't make it. You tell him, listen, I'm not going to be able, I don't have it together yet. So he agrees to postpone the closing or to set another closing in a future date to give you more time to get the financing together, right?
That's correct.
All right, and so as good faith money, you made a payment on one of your credit cards to him.
Right.
And you paid $9,000, correct?
Correct.
All right, and then what happens?
I still didn't have the rest of my financing in place, but to make things even weirder, I had a heart attack on September 5th.
Well, that makes things weird. How are you feeling?
I feel great, thank you.
Okay, how did it go
Quintuple
down?
bypass,
What did they do?
quintuple,
Oh, Lord, you're lucky to be alive.
still breathing.
Yeah.
So I was in the hospital. We were supposed to close on September 23rd. He was supposed to meet me at the hospital, never showed
wait.
up.
Why would he meet you at the hospital?
Because that's where I was. I was ready to close this deal.
Okay,
had
did
a
you
ch-
have the money?
I had the check in hand. and
How'd
have
you
a
get the
copy of
money
it.
together?
My daughter borrowed it from her 401k,
Okay. So how much were you supposed to pay to close that day?
$40,000. And you have
And
a
then where was
copy
the
of-
rest of the money going to come from? Because it was a bigger purchase than that.
We had a note.
When we had a note, that means he's supposed to, where's the note? What
In other
note?
words, part of the agreement was, it was a $50,000 down payment, a $70,000 note to be carried over 2 years.
Meaning he was taking paper. That's what I meant by
That's
taking
correct,
paper.
yes.
So you were going to owe him $70,000 and he
Correct.
agreed to that. Do you have paperwork that says any of the stuff you're saying?
Yes.
Okay. Let me hear your side.
The second agreement was a total buyout of 109,000. There was going to be a one-time
Let's see,
pay,
I can give you the whole
and that's what we
contract.
settled on, of 109,000.
When did he then tell you, I want to go back to the original plan?
The second date was September 29th.
It's supposed to close on September 29th, and then Is your version of these facts that instead of having a $109,000 check, he only had a $40,000 check?
Yes.
And then he said, I know I got you to agree to extend this deal by telling you it would be a complete buyout, no paper, but now I need you to take paper. That's what you're saying, Henry.
Right.
All right. I need you to loan me the money to buy it. All right. Now, I've read your complaint, and in your complaint, I know that you admit to telling him, give me more time, I want to do it, it'll be just, you don't have to loan me money, I'll just find the financing and I'll pay you the whole, what was this whole sum?
109,000.
109,000 is what was left after the 10,000 that was already paid?
No, a total of 109.
A total of 109. All right, so another 100,000 is what he had to come up with. Is it
108.
not true that for that closing you were supposed to come up with double the money you came up with?
We made an agreement. I tried to accommodate. It was never part
It's
of
not accommodating, it's the deal. You're supposed to do a complete buyout, right?
No. It was never part of the
Okay,
deal.
nope, let's back up. Do you have in writing that that extension was in return for a complete buyout?
Here's a note dated September 30th
That says?
for the $70,000 he wanted to do a note on. I wouldn't do it.
Right, but here's what I want. You're telling me that in return for that 9,000, it's supposed to be a complete buyout.
Yes.
You're telling me, no, it isn't.
It was never part of the original letter of intent. The letter,
That's right, but that's not my question. Did it become something you guys talked about is what I'm asking.
We talked about it. I know he wanted out, and I was trying to accommodate him.
Okay.
I went for financing, but the interest rate was so high.
That
we
you
decided-
didn't want to borrow $100,000.
Exactly.
But he thought that's exactly what you were going to do.
I don't know why he thought it, because I never told him that.
Well, you talked about it.
We talked about it, and I said I would try and accommodate
Do you
him.
have any emails from him that talk about, don't worry, I'll get all the money? Anything
No,
like
but I
that?
have a bank letter that was
Let me
emailed to me from Augusta
So
Bank.
what you're saying is he did have the money, and I think that's what he just said. He just didn't like the interest rate. Did you ever go to the hospital?
No.
Okay, because
I didn't
before
think it wasn't, I mean, he's in a hospital, he's had a heart attack. I'm going to go there and do a
The
business
day
deal.
before,
Okay, the day
I'm
before
sorry,
is.
the day before he told us he was coming.
Oh,
We
is
were
that
at the
accurate? Was
hospital.
there a plan to go?
Never planned to go. I wasn't going to go because he was in a hospital. How can I close a $100,000 deal in a hospital? And he didn't have all the money either.
Oh,
That's
so
the
you
reason
already
why.
knew he didn't have all the money.
Yes, he told me. He tried to have me sign a note. It's right there for $70,000. I waited 4 months.
If you can't afford it, you can't afford it. You had him tied up for 4 months. I mean, 4 months. And then you went to the credit card company and reversed the 9,000. Right? Did you fight that or no?
I tried. I had 30 days to fight it for my credit card company. I sent them everything in, contracts and everything.
So you did try to fight it.
They told me that they don't get involved. They just gave him back his money. So
Right.
I was
so
up, now I'm
what
at
we're
9,000.
talking about, you hink him up for 4 months, and you're trying to get that. You're trying to eke that last 1,000.
Yes.
Is that what we're talking about?
Yeah.
Because according to you, he backed out of the deal.
Right.
Except that what your argument to me is, hey, Judge, we had an original deal. I breached it because I wasn't able to close. Then I lured him to keep things open. I was trying to accommodate him. No, you're trying to keep him on the string. You're trying to string him along and keep him in. And then, I'm going to have all the money. Then a few days before the closing, you're like, well, I have all the money, but I don't feel like paying the interest rate. It's too high. There's a loan guarantee. It's 100% guaranteed. Now that I think about it, I'd rather you pay for my new limo company, and you want the last $1,000 out of the guy?
So, if this guy ended up with a quadruple bypass in the hospital with a heart attack, is that an excuse for not performing under the contract?
Yeah, I would say yes, because when you feel sick, so you think I think that we should wait before performing, before doing something, before paying.
And fair enough, it's the humane thing to do.
The human intention.
But legally, is that an excuse?
Legally, it's not. But as far as a humanely, yes.
We all agree it's the humane thing to do. Legally, what do you say?
Yeah, I agree with them. The main thing to do is that.
But legally, is it an excuse?
It's that hard line of legal and humanity.
No, it's not really that hard a line.
You're right. Legally, technically, no.
Okay, go inside the courtroom.
So you have a counterclaim against him for $2,500. It says here for time lost. What's that? What do you mean?
Time lost, 4 months of back and forth, trying to sell him a business and waiting patiently, and did the right thing to wait, not sell it to somebody else.
All right. And you feel he shouldn't have gotten the $9,000 back.
Oh, absolutely not.
because that was part of the deposit that he should have forfeited by not coming through. Can I ask you a question? Did you ever end up getting in writing that it was going to be a full payout?
No, it was all verbal for me to
I know,
wait.
you should never do that. What kind of businessman does that? You should never do that. The thing is, he kind of admits to it because he says, I was just trying to accommodate him. What he was trying to do is keep you on the string.
With that bank letter as well.
Show me that bank letter again.
I thought I was going to be scot-free.
Approval letter from the bank. He did that on July 5th.
And he kept assuring me the money's there,
Is
the
this
money's
for the
there.
first time around?
Second.
Did you guys set a second closing on the 31st
The-
of July?
Well, verbally, it was July 31st verbally.
And then what happened on July 31st?
Nothing happened. And then
Why not? What did he say was the reason nothing was
It's
going to happen?
taking longer for paperwork.
And then he's strung you along from July 31st until
Then
September.
the second, yes, then the second agreement was dated September 29th that I have right here.
Let me see any agreements you have right there that you have not shown me because I'm about to finish the case.
Second agreement.
Okay, thank you.
You'll see the closing on, I think it's the third page.
So this was entered into, this isn't signed by anybody.
Right.
Oh, well then what am I
Judge, I
looking at?
gave you the signed contracts.
Is it the same one?
Same, only contract that's in evidence that I have.
Okay, no, do you have a signed one for the September 29? You were very loosey-goosey about it, I just want to
Yes.
say.
You're
I
right.
don't have anything for September
but-
29th.
Yeah, because listen to him talk. Are you hearing the things he's saying?
Yeah.
I was just trying to accommodate him. I was being a nice guy when I said that I'd have all the money.
Yeah.
But, there's nothing in writing except for the original stuff. So now he has to agree to the original stuff. That's not how the law works. If you're, I'm not going to encourage your caginess, okay? If you can't afford it, you can't afford it. You understand that if you sue for the $2,500, you really could go to another courtroom and sue for the $9,000.
It's just not worth the stress.
Have you talked to a lawyer about it?
Yes, that's why I'm here. I did, and I just rather,
Because then you got to pay the
$2,500.
lawyer, and then it's.
yeah, I just want to get done with it and move on.
I'm going to allow you to conform your pleadings to conform to the evidence. I find that the $9,000 that he got back, he shouldn't have gotten back. I find that the $2,500 that you're asking for is extremely conservative, and I'm going to rule against you on your claim against him and for you on your claim against him. Now, understand that this is not an award for you for being so let along. You're kind of, you don't act like a guy who's been in business for 20 years.
I was like that rabbit with the carrot,
Yes, yes, you were. And then you kept doing whatever anybody wanted.
Yeah,
You kept hopping and skipping and jumping and doing what everybody wanted without the least. I mean, when I say not in writing, I'm not even talking about written contracts. I'm talking about an email. Confirm in an email, these are our understandings. These are the 10 things we just agreed on. Why is that so hard?
I believe
Make sure
them.
the man starts using social media.
Yeah.
All right? It's not just for social. All right. Take care, folks.
Thank you.
So the plaintiff loses his attempt to get $1,000 back. I think the judge thinks you were really kind of cagey here, stringing him along. You're shaking your head now.
I disagree entirely.
Well, what do you have to say?
All I have to say is I'm a big fan of the judges, and if she said I was wrong, then I was wrong.
Okay, well,
Simple as that.
good for you. All right.
I'm glad it's over.
I'm sure you are. All right, thank you very much. Hopefully you've learned something from all of this. Same thing for you, Mr. Wilkins. Obviously, as she said, you were a little loosey-goosey, as she put it.
She is right.
Yeah.
I don't do any social media, and she's right.
Okay. You can teach him, right?
Absolutely.
About social media? I'm sure she can. Next time, get some signed contracts.
Yeah, I'm gonna definitely do it
Yeah,
next
you
time.
learn a lesson. Okay, well, at least you did win, so congratulations.
Thank you.
Okie dokes. Good enough. Harvey?
Okay, Doug, illness, period, is just not an excuse for not performing under a contract. It is not necessarily the humane thing. Legally, that's the law.